Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us today. Hey, previously we posted a video about red flag laws in Washington State. We'll put the link down below there. But did you know in Washington State we also have what I call white flag laws? That is a law where a person can voluntarily forfeit their firearm rights for a specified period of time. So I thought we'd spend a few minutes today talking about, can I really voluntarily forfeit my firearm rights in Washington State? Well, before we get into this, remember, if you like this video, go ahead and click that like button down below if you want to stay apprised of all your Second Amendment rights, not only on a statewide level, but on a nationwide level. Go ahead and click the subscribe button down below. And if you click that little bell logo down below, you'll get notified when we post new videos. So today we're going to be talking about what I call white flag laws in Washington State. Now we know what red flag laws are. Red flag laws are essentially an individual can go to a court of law and petition to have the Second Amendment rights of another individual removed for up to 1 year. And then of course the order is renewable upon further showings. Now, the individual has to demonstrate that the person who they're trying to restrain from having firearms poses a risk to themselves or to others and has access to firearms. And upon showing that, the court can order that their Second Amendment rights are suspended for a period of 1 year. Now, we also have something in the RCWs, which is basically a white flag law, and this allows an individual to voluntarily surrender their firearm rights for a period of time, no less than 7 days. And I'm going to talk about that, and we're going to get you familiar with two statutes today, 9.41.350 and 9.41.352. Now, these statutes were created through a piece of larger legislation that passed in 2018. Substitute Bill 5553 was the legislation. It was signed into law in 2019 by Governor Inslee. And this was part of, as I mentioned, a larger suicide prevention. And the purpose of this statute, I think people's hearts were in the right place here. The purpose of this statute is to allow individuals to voluntarily surrender their firearm rights, and in doing so, also provide some confidentiality protections that I think are important to discuss here today as well. So I think what we're going to do today is we're going to talk about three things. We're going to talk about two statutes, and we're also going to talk about why would a person want to voluntarily surrender their firearm rights. Because I know when we first bring that up, it's kind of a why would a person want to do that? And I think there are a couple of reasons for which a person can do that, or maybe it would be the right move for a person to do that. So the first statute we're going to talk about today is RCW 9.41.350. That is the voluntary waiver of firearm rights. And that statute reads as follows. A person may file a voluntary waiver of firearm rights with the clerk of the court in any county in Washington State. The clerk of the court must request photo identification to verify the person's identity prior to accepting the form. The person filing the form may provide an alternate person to be contacted if a voluntary waiver of firearm rights is revoked. By the end of the business day, the clerk of the court must transmit the accepted form to the Washington State Patrol. The law further goes on to state then that the Washington State Patrol must enter the voluntary waiver of firearm rights in the National Instant Criminal Background Check System and any other federal or state computer-based systems used by law enforcement agencies or others to identify prohibited purchasers of firearms within 24 hours of receipt of the form. Copies and records of the voluntary waiver of the firearm rights shall not be disclosed except to law enforcement agencies. So as you can see, what the statute says is that the clerk of every court in Washington State must provide a form, and an individual who comes in there with photo identification and wants to forfeit their firearm rights can fill out this form, and upon the clerk checking the verification, verifying the information stuff, will immediately notify the Washington State Patrol, who then immediately notifies all other relevant law enforcement agencies who manage background check systems. So once the court has accepted a voluntary waiver of firearm form, essentially allowing the individual to forfeit their firearm rights, how does one go about reestablishing their rights? That is, revoking that waiver. Well, subsection 2 of the same statute tells us that, and it reads as follows. no sooner than 7 calendar days after filing a voluntary waiver of firearm rights, the person may file a revocation of the voluntary waiver of firearm rights in the same county where the voluntary waiver of firearm rights was filed. The clerk of the court must request photo identification to verify the person's identity prior to accepting the form. By the end of the business day, the clerk of the court must transmit the form to the Washington State Patrol and to any contact person listed on the voluntary waiver of firearm rights and destroy all records of the voluntary waiver. Within 7 days of receiving a revocation of a voluntary waiver of firearm rights, the Washington State Patrol must remove the person from the National Instant Criminal Background Check System and any other federal or state computer-based systems used by law enforcement agencies or others to identify prohibited purchasers of firearms in which the person was entered, unless the person is otherwise, of course, ineligible to possess a firearm for other reasons, and they must destroy all of the records of the voluntary waiver. So, to revoke the document, you need to file a form asking for the revocation in the same court where you filed the voluntary waiver of the firearm rights. You have to verify all your information through photo ID, and that form cannot be filed with the clerk of the court any sooner than 7 calendar days following the date you entered the voluntary waiver. So at a minimum, these voluntary waivers are going to last 1 week. Okay, so there's some other sections of the statute that I also want to make you aware of. That's sections 3 through 6, and let's go through those real quick as well, because there's some very important privacy considerations in this statute. Section 3 tells us that a person who knowingly makes a false statement about their identity on either the form to waive the firearm rights or to revoke that waiver would be guilty of false swearing under 9A72040. That should be a surprise to nobody. More importantly to you, Section 4 says that neither a voluntary waiver of firearm rights nor the revocation of a voluntary waiver of firearm rights shall be considered by a court in any legal proceeding. I think that's very important. Number 5 says a voluntary waiver of firearm rights may not be required of an individual as a condition for receiving employment, benefits, or services. And finally, subsection 6 here, all records obtained and all reports produced as required by this section are not subject to disclosure through the Public Records Act under Chapter 42.56. And I cannot express to you how important that is that with the voluntary waiver of firearm rights, there is a record maintained of it while you have voluntarily waived those rights. But when you revoke that waiver, all records are destroyed, not only at the court, but also with law enforcement. So if all agencies are following the statute as they're supposed to, there will literally be no trace of this once that waiver has been revoked. The other statute that I want to talk about very briefly today is 9.41.352. We'll put the link for that statute down below, but essentially that statute directs the clerk of the court to promulgate a form. It needed to be done by January 1st of 2019. Obviously, that's since been done. And we've put a link for both what a sample voluntary waiver of firearm rights and a revocation of that voluntary waiver of firearm rights form look like. We got links for both of those down below. Essentially, these forms are promulgated by the statute, by court rule, and are pretty similar no matter which jurisdiction you go to. So the final thing I want to talk about today is, why would a person do this? Okay, because I know that is the kind of head-scratching question. Well, I think we need to be honest about one thing, and that is that we do have a suicide problem in this country. I do not believe there is any debating that. I do not believe our suicide problem is caused by handguns, but certainly the access to handguns makes suicide attempts far more successful. It is one of the most effective means of actually carrying out a suicide. The problem, of course, is that we as a country have not really well tended to our overall mental health issues and still have a long way to go to catch up with properly dealing and even recognizing and managing mental health issues. And so part of what we in the Second Amendment community really cherish is that right of freedom and the right of free will and the ability to make our own choices. And so an individual, a Second Amendment person, a person who does lawfully and responsibly possess firearms, who suddenly is feeling some type of emotional trauma, is going through a very difficult time and for whatever reason is concerned for their own safety, why not give them the opportunity to manage their own safety in a way where they can control the outcome and they can dictate the terms? And I think that if we take a step back and we consider what we cherish the most, which is our ability to make choices for ourselves, our free will, you can see where this statute clearly had some good intentions and could be used very properly by very lawful and responsible gun owners. Now, a second thing is this, is that we in the Second Amendment community are greatly concerned about the red flag laws and that people can make salacious allegations and arguably have the Second Amendment rights of a person removed from them for at least a year and in some cases longer than that. The ability to essentially enter a white flag order prior to having a hearing on a red flag order could, in the eyes of some jurisdictions, now leave the petitioner of the red flag order without standing. Because the whole cause of action in a red flag hearing is to remove temporarily the firearm rights of the respondent. However, if the respondent has themselves voluntarily removed their firearm rights and there is an active order in place, does the court have standing? And so I think there could be some legal maneuvering there as far as ways to defend individuals from red flag hearings, or what we call in this state extreme risk protection orders, ERPOs. Well, listen, I hope that answers some of the questions you may have about voluntary waiver of firearm rights in Washington state and how to revoke that. You may have more questions about this or anything related to your Second Amendment rights, not only on a statewide level, but on a nationwide level. And if you do, don't hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Listen, part of being a lawful and responsible gun owner, like we preach here all the time, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.